Hey everybody, I just want to go over some information for Module 7 and cover some key concepts that I think you'll find useful as you prepare for your final project, which is due this week. And so I'll discuss a little bit more about that towards the end of this hopefully short little lecture. So I just want to talk a little bit about discovery. I mentioned that a little bit in my announcement, but more from a civil perspective. So I want to spend a little bit of time talking about discovery in terms of prosecutorial and defense attorney type of discovery, just a thumbnail overview. Then I want to spend a little bit of time talking about statute of limitations, since that is the subject for your final project. I don't think the textbook covers it very well, or if at all. So I just want to touch on statute of limitations just for a little bit so you have an idea as to what it is. And then I just want to talk a little bit about, I have a chart here for you, just briefly talking about the court process, because that is also mentioned in your final project, in which you have to look at the litigation process. And so we're just going to pose it from a criminal perspective, since our case is a bank robbery. Okay, so those are really the three things that I want to go over here real quick. All right, so we'll quickly talk a little bit about discovery, so you have an idea as to what we're referring to when we talk about discovery. I mentioned in my written version of discovery that takes place at the civil trial. And so there are some similarities between the criminal aspect and civil aspect, but we'll talk specifically about the criminal case. Okay. Now, discovery is the process through which defendants find out about the prosecution's case. And for example, through standard discovery procedures, they can get copies of the arresting officer's reports and statements made by prosecution witnesses and so forth. And they can examine evidence that the prosecution proposes to introduce at trial. Now, traditionally, the prosecutor wasn't entitled to information about a defendant's case. In other words, if the defense had information, typically in the past, the prosecutor was not entitled to that information. However, in recent years, discovery has become more of a two-way street. Just as defendants can discover information about the prosecutors, so too can prosecutors examine certain evidence in the hands of defendants. And so now it's a bit more even, a little more level playing field in terms of discovery and obtaining information. So in theory, if a defense lawyer has information that would indicate, for example, an alibi, then he's obligated to provide that information to the prosecutor, because obviously the prosecutor needs to validate that alibi. And obviously, if it's true that the defense was someplace else, or the defendant was someplace else, then that might change the outcome of the case or the strategy used by the prosecutor. So again, discovery nowadays is a two-way street in terms of how that's going to be applied. So the modern discovery policy is pretrial disclosure of information to discovery can foster settlement and enhance the fairness of trial. So obviously, discovery allows the other side to determine the strength of the evidence, the type of evidence, and so forth. And so in some respects, it may bring about a quick resolution to a case, maybe a plea bargain or something to that effect. Okay. So the question often becomes, and we've seen it on TV a lot of times, and whether prosecutors can, all of a sudden spring evidence on defendants like they do on TV. In other words, all of a sudden you have this, the silver bullet, so to speak. Well, the answer is really no, they can't. In the past, prosecutors could guard evidence from defendants with the same fervor toddlers show in protecting toy trucks and dolls from their siblings. Defendants couldn't force prosecutors to hand over witness statements or even reveal the names of their witnesses. Now the view that advanced disclosure will promote fairer trials has taken hold. If defense attorneys know ahead of time what to expect, they can better defend their clients. And I think that's essential, because if, for example, a prosecutor withholds evidence or does so in such a manner that it does not give the defense ample time to prepare for cross-examination, then in theory that could be used as a means to appeal a conviction, okay? So we get back to our surprise evidence. Surprise evidence may produce fine drama, but it leads to poor justice. Unlike prosecutors, defendants can't call on police agencies to help them investigate and respond to evidence that they find out about for the first time at trial. Thus, every jurisdiction, each state and the federal government, has discovery rules requiring prosecutors to disclose evidence to defendants prior to trial. So each state and the federal government has rules. Now, some of those rules may be similar, but just know that there are discovery rules binding how and when discovery is to take place. And again, we get back to the whole idea that we've been talking about, and that is creating a system of justice that is not only efficient and effective, but also fair, okay? And that's going to be important. Does discovery rules help defendants? Not necessarily, not exclusively. Some evidence may advance disclosure, promotes fair trial outcomes, but it also promotes case settlement, which saves judicial time and resources. If a guilty defendant finds out before trial that the prosecution has a particularly strong case, then the defendant may be more willing to plead guilty to save the government the hassle of trying the case. Discovery is likely a significant reason why at least 90% of criminal cases settle before trial. And so that's important. So discovery does have a benefit. Again, it does sort of allow each side to sort of gauge the strength and weaknesses of not only the prosecutor's case but also the defense case. But it can be very, very significant and helpful in trying to move some cases along. Does discovery mean that the prosecution has to reveal its case strategy? Absolutely not. Discovery rules generally distinguish between raw information like names of witnesses, police reports, drug or alcohol test results, and attorney theories and strategies. The latter, the attorney theories and strategies, are what is known as work product, and the work product does not have to be disclosed. That's something that's confidential with the attorney himself. Okay. So here's an example for purposes of discovery. Let's say that I am charged with assault and battery on a police officer. I claim that I reacted in self-defense to a police officer's use of illegal force. The prosecutor plans to show a videotape of the incident to the jury. The prosecutor also has prepared a file memorandum as a self-reminder about what portions of the tape to emphasize during the trial and why those portions are especially significant. My lawyer demands to see the videotape and all the prosecutor's trial memoranda. Now, discovery rules would allow my lawyer to see the videotape, but not the prosecutor's notes or memoranda, because those are work products. So work products are not part of discovery, okay? That's the example. When should discovery occur? Is there a particular period of time prior to trial when defense is supposed to engage in discovery? Not really. Prosecutors can't disclose all discovery on the eve of trial. But on the other hand, they don't have to divulge it all way ahead of time either. Discovery can unfold gradually. For example, a defendant's attorney might receive a copy of a police report at the first court appearance, but might not receive a prosecution's expert's written analysis of blood evidence until shortly before trial. And some of that is obviously those type of things may take time for the evidence to come forward. Okay, but that's a little bit about discovery and prosecution's case. Again, it does help move things along, and it is now more of a two-way street, and both state and federal courts now have standards and guidelines as to when this type of legal maneuvering takes place. Okay, what is statute of limitations? Because that's also going to be part of your final project. Statute of limitations is basically a law which forbids prosecutors from charging someone with a crime that was committed more than a specified number of years ago. And so what this means is that each crime statutorily has a statute of limitations. Now, some don't have a statute of limitations, as we mentioned, we'll talk with down here, but most have a statute of limitations. For most cases, in most states, for example, a misdemeanor might have a year for statute of limitations. In other words, a prosecutor has 1 year to bring charges against somebody for a misdemeanor. In some states, felonies might have a 3 to 5 year statute of limitations. Okay, an example I have here is most federal crimes, with some exceptions, have a 5-year statute of limitations. So, mail theft, for example. So the prosecutor has a certain amount of time with which to bring charges forward. If they fail to do so, then they won't be able to bring criminal charges against the defendant. Okay, so it's going to vary state by state, but just understand that there are statute of limitations that are associated with all crimes. Now, again, not all crimes are governed by statute of limitations. Murder, for example, has none. In some states, sex offenses with minors, or crimes of violence, kidnapping, arson, maybe even forgery, have no statute of limitations. In Arizona and California, crimes involving public monies or public records, in other words, where a person is a public official and he or she embezzles public monies or public funds, has no statute of limitations. So statute of limitations, again, limits the amount of time that a prosecutor has to bring a case forward and others prosecute somebody. And it's going to vary by state and level of government. So the federal government might have different statute of limitation rules than states do, but generally speaking, all states and the federal government have some level of statute of limitations that are associated with their crimes, okay? So there's a certain amount of time that they can bring charges forward. Last thing I want to talk about is what is criminal litigation process, and we do have a question regarding criminal litigation. And basically we're talking about that process that takes place in our judicial system from the time that one gets arrested to the time that one is punished. And that's basically the litigation process. Now, the litigation process, the beginning part of that process might vary from states to state and the federal government. Remember that the federal government uses the grand jury system. Some states also use the grand jury system. Other states do not use the grand jury system. Some states use a preliminary hearing process to determine whether or not there's enough evidence to bring someone to trial, whereas some states in the federal government might use the grand jury system as a means to determine whether or not there's enough evidence to indict somebody with it. For example, if using the grand jury, have a true bill. So basically they're indicting someone. States that use the preliminary hearing process then file an information. And so what I've done this week is I have included a chart for you that'll be in the announcement. You could take a look at that. But basically, it's the process. So when we talk about, the litigation, criminal litigation process, that's what we're referring to. It's basically an array of things that we've been talking about for the last several weeks. And so hopefully that chart will help you. Again, I think the biggest difference between looking at state litigation process and the federal government litigation process is the use of the grand jury system. And everything that goes on in between. So from the time a person gets arrested and charged with a crime, gets arraigned, preliminary hearing or grand jury, the adjudication process, sentencing and sanctions and those type of things, those are all part of basically what we've been talking about over the last several weeks, okay? Finally, regarding your paper now, there are some things I want to remind you. So first of all, obviously, the project is due this week. So please make sure you review and include any corrections offered on your previous milestones. And please make sure you look at all the categories that are part of this assignment, because some of those may not have been covered in